Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in FDA v. Wages and White Lion Investments, LLC. In this case, the court considered this issue. Was the Food and Drug Administration's orders denying respondents' applications for authorization to market new e-cigarette products arbitrary and capricious, in violation of the Administrative Procedure Act? The case was decided on April 2, 2025. The court unanimously held that the FDA's decisions were neither arbitrary nor capricious. Specifically, the court agreed with the FDA's assessment that the manufacturers failed to demonstrate that the benefits of their flavored products to adult smokers outweighed the risks to youth. This ruling reversed a prior decision by the Fifth Circuit Court of Appeals, which had found the FDA's denials unwarranted. The Supreme Court's decision underscores the FDA's authority to regulate tobacco products, particularly those appealing to younger audiences, in line with public health objectives. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Alito delivered the opinion of the court. This case concerns the efforts of the Food and Drug Administration, FDA, to regulate the sale of e-cigarettes, a product that rapidly gained popularity during the past 20 years. The governing federal law, the Family Smoking Prevention and Tobacco Control Act of 2009, TCA, restricts the sale of all tobacco products that were not commercially marketed in the United States before February 15, 2007. Unless otherwise authorized, a manufacturer may not introduce such a product to the market until the FDA determines that it is appropriate for the protection of the public health. In this case, we consider whether the FDA lawfully denied authorization to market certain flavored e-cigarette products. One of the FDA's long-standing responsibilities, dating back nearly a century, is to determine whether manufacturers may market new drugs. For much of that history, the FDA lacked jurisdiction to regulate tobacco products. By the time Congress conferred that authority in 2009, a new product was ascended on the market, the e-cigarette. This product offers existing smokers a potentially safer alternative to traditional combustible cigarettes. But e-cigarettes carry their own health risks, and they come in a dizzying array of flavors, many of which, such as dessert, candy, and fruit flavors, are particularly appealing to the young. The surging youth demand for flavored products, and the prospect of a new generation of smokers, caught the FDA on its back foot. In 2016, the agency declared that manufacturers of e-cigarette products would need to obtain the same marketing authorization that is required for other tobacco products. The FDA's regulatory efforts culminated in the 2021 denial of over 1 million applications for flavored e-cigarette products. The dispute before us arises from that mass denial. The Pure Food and Drug Act of 1906 was Congress's first foray into the comprehensive regulation of food and drugs. The act prohibited the interstate transportation of any article of food or drugs which is adulterated or misbranded. That act also vested important responsibility in the precursor to the FDA, the Bureau of Chemistry in the U.S. Department of Agriculture. But early in its tenure, the Bureau disclaimed any authority to regulate tobacco products labeled in such a manner as to indicate their use for non-medicinal purposes like smoking or chewing or as snuff. Congress later renamed the Bureau of Chemistry, first as the Food, Drug and Insecticide Administration and then as the FDA, the name by which we know it today. In 1938, Congress enacted the Federal Food, Drug, and Cosmetic Act, FDCA, which vastly expanded the FDA's regulatory authority over drugs and devices. One of the FDCA's major innovations was the establishment of a system for pre-market authorization under which manufacturers are prohibited from marketing any new drug in interstate commerce without the FDA's approval. To receive such authorization, manufacturers must prove to the FDA that their new products are safe for use. And if the FDA has insufficient information to make that determination, it must issue an order refusing marketing authorization. By the middle of the 20th century, nearly 1 in 2 Americans regularly smoked. Toward the latter half of the century, however, the public became increasingly aware of the great potential hazard of tobacco and the addictive properties of nicotine. The FDCA was enacted long before public awareness of the dangers of smoking became widespread, and neither its text nor its legislative history provided any indication that tobacco products fell within the FDA's jurisdiction. Thus, during the first 60 years after the FDCA's enactment, the FDA, like the Chemistry Bureau, repeatedly stated that it lacked authority under the FDCA to regulate tobacco absent claims of therapeutic benefit by the manufacturer. Tobacco regulation was largely left to Congress, which enacted various statutes between 1965 and the turn of the century to address the harms of tobacco use, including the imposition of warning requirements, restrictions on the advertisement of certain tobacco products, and requirements that the Secretary of Health and Human Services report on scientific findings about, among other things, the addictive property of tobacco. and age restrictions on the sale or distribution of tobacco products. At no point during that period did Congress grant the FDA jurisdiction to regulate tobacco or tobacco products under the FDCA. Against that backdrop, Congress enacted the Family Smoking Prevention and Tobacco Control Act of 2009. The TCA vests the Secretary of Health and Human Services, acting through the FDA, with the authority that this court previously found lacking, namely, the power to regulate the manufacturing, marketing, sale, and distribution of tobacco products. The TCA explicitly granted the FDA regulatory authority over cigarettes, cigarette tobacco, roll-your-own tobacco, and smokeless tobacco. It also granted authority to regulate any other tobacco products that the FDA by regulation deems to meet the definition of a tobacco product. The TCA's reach was broad. While the Act barred the FDA from banning all regulated tobacco products outright or requiring manufacturers to reduce nicotine yields to zero, it prohibited a manufacturer from marketing any new tobacco product without FDA authorization. A new tobacco product is one that was not marketed in the United States before February 15, 2007, and the TCA subjected such products to a pre-market authorization process. One pathway to authorization of the sale of a new tobacco product is the submission of a pre-market tobacco product application. These applications require, among other things, information about a product's components and additives, the method by which it is manufactured, any proposed labeling, and an assessment of its health risks. There are many reasons why the FDA may deny marketing authorization to a new tobacco product, but of main importance here, the agency must deny an application unless it is shown that the product would be appropriate for the protection of the public health. To determine whether a product meets this standard, the FDA must consider the risks and benefits to the population as a whole, and take into account the increased or decreased likelihood of two outcomes. First, that the new product will induce users of existing tobacco products such as conventional cigarettes to stop using those products, and second, that those who do not use tobacco products will start using them. The FDA's determination regarding the likely effects of a new product must, when appropriate, be based on well-controlled investigations or other valid scientific evidence that is sufficient to evaluate the tobacco product. The FDA must act as promptly as possible on a pre-market tobacco product application and in no event later than 180 days after the receipt of an application. If the FDA denies an application for pre-market authorization, any person adversely affected by the denial has 30 days to seek judicial review in a court of appeals. The reviewing courts must in turn apply the provisions of the Administrative Procedure Act, APA. At the end of the 20th century, tobacco manufacturers tried without much luck to market safer alternatives to traditional cigarettes, such as smokeless cigarettes. But in 2007 a new product hit the American market, electronic nicotine delivery systems, which are popularly known as electronic cigarettes, e-cigarettes, or vapes. Practically overnight, e-cigarettes became ubiquitous. Sales for e-cigarette products surged exponentially after 2010. And according to one estimate, 11.2 million American adults used e-cigarettes by 2016. The impetus for the invention of e-cigarettes was the desire to create a product that would reduce the health risks of smoking. A traditional combustible cigarette contains shredded tobacco wrapped in paper, and when lit, the tobacco catches fire and produces smoke, which contains nicotine and tar, a complex chemical mixture of more than 7,000 compounds that cause a wide range of diseases. In contrast, an e-cigarette contains a battery, a heating element or atomizer, a liquid nicotine reservoir, and a mouthpiece. When an e-cigarette user inhales through the device's mouthpiece, the heating coil engages, and the liquid, called e-liquid or e-juice, turns into a nicotine-infused vapor. Unlike a traditional cigarette, an e-cigarette does not release tar or other byproducts of combustion, but it does emit potentially toxic substances, including fine particulate matter, metals, and, of course, nicotine. E-cigarettes typically come in either a closed or open system. Closed-system e-cigarettes contain a set amount of e-liquid that is determined by the manufacturer. Some closed-system products are designed to be discarded after the e-liquid supply runs out, while others can be reused by inserting a cartridge or pod that contains e-liquid. By contrast, an open-system e-cigarette contains a tank that users can manually refill with the desired amount of e-liquid. Users of open-system products may mix their own e-liquids and adjust the amount of e-liquid in the tank. There is fierce public debate about the potential benefits and harms of e-cigarettes. On one hand, many view e-cigarettes as a harm reduction tool. They enable current smokers who are addicted to nicotine to reduce exposure to some of the more harmful byproducts of traditional combustible cigarettes. On the other hand, e-cigarettes, as noted, pose their own health risks, and there is concern that the use of e-cigarettes by non-smokers, and especially young non-smokers, may eventually lead them to smoke conventional cigarettes. Early on, evidence began to mount that young Americans are particularly drawn to e-cigarette products. By the mid-2010s, approximately 2.4 million high school students and 620,000 middle school students reported using an e-cigarette at least once in the last 30 days, and a more recent estimate suggests that approximately 3.6 million American middle and high school students used an e-cigarette within a 30-day period. One particular feature of e-cigarette products appears to drive this youth demand: the panoply of e-liquid flavors. One nearly decade-old estimate found that there were 7,700 unique e-liquid flavors, including not only flavors that were familiar to cigarette smokers, tobacco and menthol, but also fruit, candy, and dessert flavors that were appealing to non-smokers. The kaleidoscope of flavor options adds to the allure of e-cigarettes and has thus contributed to the booming demand for such products among young Americans. Because the popularity of e-cigarettes is a relatively recent phenomenon, these products initially escaped the FDA's regulatory reach, but in 2016, the FDA issued a rule deeming e-cigarettes and e-liquids to be tobacco products. Since most e-cigarette products were not commercially marketed in the United States as of February 15, 2007, the deeming rule retroactively rendered such products new tobacco products subject to the TCA's pre-market authorization regime. And because those products had not received pre-market authorization, the effect of the rule was to make their continued sale illegal. Companies that proceeded to sell their products without such authorization would be subject to stiff penalties. To give these manufacturers adequate time to apply for pre-market authorization, the FDA delayed enforcement for 2 to 3 years. This permitted e-cigarette products to remain on the market while manufacturers filed their applications. Initially, applications were due by August 8, 2018. The FDA later tried via guidance to extend the compliance deadline through 2022, but a federal district court ultimately imposed a deadline of September 9, 2020, adding to the time crunch for compliance. At the center of this case are the FDA's actions leading up to its adjudication of manufacturers' pre-market tobacco product applications. The agency proposed a rule outlining application requirements, issued guidance to assist e-cigarette manufacturers, and crafted internal memoranda discussing how applications were to be reviewed. These voluminous and discursive documents paint a picture of an agency that was feeling its way toward a final stance and was unable or unwilling to say in clear and specific terms precisely what applicants would have to provide. Pervading these documents are 4 overarching topics that animate the dispute before us. The first topic was the types of scientific evidence needed to show that an e-cigarette product is appropriate for the protection of the public health. Recall that the TCA states that well-controlled investigations may support such a showing when appropriate, as can other valid scientific evidence if found sufficient to evaluate the tobacco product. At an October 23, 2018, public meeting, an FDA official opined that in most situations, the FDA would expect some analytical testing specific to a manufacturer's product. But the FDA also assured manufacturers that no specific studies, youth behavioral data, or new non-clinical or clinical studies would be required. The FDA said much the same thing in a lengthy 2019 guidance document, noting that the relatively new entrance of e-cigarette products meant that limited data may exist from scientific studies and analyses. So, according to this document, the FDA would not require long-term studies, and manufacturers could instead rely on various alternatives, like observational studies, literature reviews, or evidence bridging their new tobacco product to a studied tobacco product. After manufacturers submitted millions of applications for flavored e-cigarette products, the FDA developed a new plan to effectively manage the scientific evidence underlying the onslaught of applications. In a July 9, 2021, internal memorandum, the FDA took a far less capacious view of the scientific evidence it would consider. Specifically, the FDA said that it would consider it a fatal flaw if an application lacked scientific evidence about a product based on either a randomized controlled trial or a longitudinal cohort study. A fatal flaw would lead to a manufacturer's likely receiving a marketing denial order for that product. Over a month later, on August 17, 2021, the FDA issued another internal memorandum that differed in some respects from the July memorandum. It stated that, in addition to randomized controlled trials and longitudinal cohort studies, the FDA would also consider evidence from another study design, provided that it could reliably and robustly assess behavior change and compare users of flavored products with those of tobacco-flavored products. Then, on August 25, 2021, just before denying respondents' applications, the FDA rescinded the August 17, 2021, memorandum and stated it would not consider or rely on it when evaluating pre-market tobacco product applications. The second topic was the need for manufacturers to compare their proposed products to other products. The TCA requires pre-market tobacco product applications to provide full reports of all information concerning investigations which have been made to show that a new product presents less risk than other tobacco products. Elaborating on that standard at a presentation on October 23, 2018, an FDA official encouraged applicants to provide comparisons between their products and a representative sample of tobacco products on the market. And a 2019 guidance document similarly recommended comparisons of the health risks of a manufacturer's product to both products within the same category and subcategory, as well as products in different categories as appropriate. The 2019 guidance also gave manufacturers discretion to choose comparator products as long as the FDA could understand an applicant's rationale and justification for the comparators chosen. Later that year at a public meeting, an FDA official offered the same general advice that a successful pre-market tobacco product application may include comparisons to other tobacco products in the same category or in other categories or subcategories. In a lengthy April 2020 guidance document, the FDA elaborated on a third theme: its enforcement priorities based on device type. The agency said it would prioritize enforcement of flavored, cartridge-based e-cigarette products other than tobacco and menthol-flavored products. It claimed that youth overwhelmingly prefer cartridge-based products, which are easy to conceal, can be used discreetly, may have a high nicotine content, and are manufactured on a large scale. And the document asserted that certain flavors, such as candy and fruit flavors, are a strong driver for youth use. Although the FDA suggested that its focus on flavored, cartridge-based products should have minimal impact on small manufacturers, for example, vape shops, that primarily sell non-cartridge-based products, it noted that it would also prioritize enforcement against all other e-cigarette products for which the manufacturer has failed to take, or is failing to take, adequate measures to prevent minors' access, as well as any e-cigarette product that is targeted to minors or whose marketing is likely to promote use of e-cigarettes by minors. The final theme cutting across these documents is the FDA's unflinching advice that manufacturers should submit marketing plans as part of their applications. Marketing plans broadly refer to a manufacturer's specific restrictions on sale and distribution that could, for example, decrease the likelihood that those who do not use tobacco products will start using tobacco products. In its 2019 guidance, the FDA urged manufacturers to share their marketing plans to enable FDA to better understand the potential consumer demographic of their products. The 2020 enforcement guidance hit the same note, suggesting the FDA intended to consider marketing plans and that such plans would be relevant to the agency's enforcement prioritization. The FDA even offered examples of what marketing restrictions manufacturers might consider, including screening retailers, age verification technology, mystery shopper programs, controls over distributors, and quantity limits. It also cautioned that, based on its experience, focusing on how the product was sold and age verification would not be sufficient to address youth use. In 2019, the FDA proposed a rule setting out the requirements for pre-market tobacco product applications. That proposed rule, in significant part, crystallized the four themes discussed above. It offered specifics on the types of scientific investigations that applications would be required to contain. The proposed rule also required certain cross-product comparisons, and it underscored the importance of device type with respect to product testing. In addition, the proposed rule obligated manufacturers to submit marketing plans, which were described as providing input that is critical to the agency's review. Notice and comment rulemaking takes time, and with a court-imposed deadline fast approaching, the FDA proceeded to adjudicate the first major wave of pre-market tobacco product applications in August and September 2021 without a final rule, and the standards it included. It was not until October 5, 2021, that the FDA adopted the final rule. Respondents Wages and White Lion Investments, LLC, doing business as Triton Distribution, and Vapetasia, LLC, manufacture flavored e-liquids for open system e-cigarettes. Their e-liquid flavor offerings include Killer Custard Blueberry, Rainbow Road, Iced Blackberry Lemonade, Pineapple Express, Suicide Bunny Mother's Milk and Cookies, and Blueberry Parfait. Respondents submitted pre-market tobacco product applications on September 9, 2020, the final court-ordered deadline. As the FDA recommended in its guidance, their applications included marketing plans, which touted respondents' use of third-party age verification technology, quantity limits, and requirements for retailers to develop compliance checks. To show the safety of their products, respondents pooled resources with other, similarly situated e-liquid companies to fund the development of certain required non-product-specific data, including what they characterized as a comprehensive review of the scientific literature. One of the respondents, Vapetasia, also submitted the results of a cross-sectional survey of current and former adult e-cigarette smokers. The FDA received applications from more than 500 companies in total, covering more than 6.5 million e-cigarette products. Almost a year after the court-ordered deadline, the FDA adjudicated its first slate of pre-market tobacco product applications and issued marketing denial orders to 3 manufacturers whose applications covered 55,000 flavored e-cigarette products. The FDA concluded that the manufacturers failed to provide sufficient product-specific scientific evidence to demonstrate enough of a benefit to adult smokers that would overcome the risk posed to youth. Such scientific evidence, the agency said, would likely be in the form of a randomized controlled trial or longitudinal cohort study, but the FDA promised that it remained open to other types of evidence that are sufficiently robust and reliable. Shortly thereafter, the FDA denied respondents' applications. It concluded that respondents had not provided sufficient scientific evidence to demonstrate that the marketing of their products would be appropriate for the protection of public health. Specifically, the FDA held respondents had not provided evidence from a randomized controlled trial, longitudinal cohort study, or another reliable and robust method showing that their dessert, candy, and fruit-flavored products had benefits over an appropriate comparator tobacco-flavored product. With such evidence lacking, the FDA deemed respondents' products misbranded and adulterated under the FDCA. To each denial order, the FDA appended a Technical Project Lead (TPL) review. These lengthy documents have several noteworthy features. To start, they offer a window into the FDA's evolving understanding of how flavor, regardless of e-cigarette device type, drives youth smoking initiation and nicotine addiction. The reviews canvass the scientific literature on youth e-cigarette use and explain that this literature had led the agency to conclude that flavors make e-cigarette smoking more palatable for novice youth and young adults, and may increase nicotine exposure by potentially influencing the rate of nicotine absorption. What is more, the FDA stated, young people are drawn to particular flavors, and the FDA anticipated that its crackdown on one type of e-cigarette device would lead youth to flock to a different type of device to continue using a desired flavor. Despite the FDA's prior representations about the importance of marketing plans, the review stated that, for the sake of efficiency, the FDA had decided not to evaluate respondents' marketing plans. The FDA acknowledged that it is theoretically possible that significant mitigation efforts could decrease the appeal of flavored e-cigarettes to a sufficient degree to counterbalance the documented risks of such products, but it found that none of the marketing plans the FDA had seen had managed to do that. The FDA estimates that in its first wave of marketing orders, it issued denials to 320 applicants, who sought approval for approximately 1.2 million products. Respondents petitioned for review in the Fifth Circuit. A motions panel initially granted a stay of their marketing denial orders pending review, but a divided merits panel ultimately denied the petitions. The court then reheard the case en banc, granted respondents' petitions for review, and remanded to the FDA. The en banc majority held that the FDA had acted arbitrarily and capriciously in denying respondents' applications. In its view, the FDA performed a surprise switch from the requirements articulated in the various pre-decisional documents. The court pointed to several main examples of this phenomenon, including the FDA's positions on scientific evidence, cross-flavor comparisons, and device type. The court expressed particular concern that the FDA pulled the rug out from under manufacturers by not even reading the marketing plans it previously said were critical. Although the FDA's attorneys represented that the agency had reviewed summaries of respondents' marketing plans, the court deemed that representation an illicit post hoc rationalization. In a footnote, the en banc majority also suggested that the FDA had violated a provision of the TCA's notice and comment requirements by imposing a de facto ban on flavored e-cigarettes through mass adjudicatory denials. Having found that the FDA had erred in these ways, the court rejected the FDA's suggestion that any errors were harmless. Relying heavily on prior decisions, the court suggested that APA errors are only harmless where the agency would be required to take the same action no matter what. In all other cases, the court concluded, an agency cannot avoid remand. And, in a brief alternative analysis, the court found that each of the FDA's errors plainly affected the procedure used and was prejudicial. Judge Haynes, joined by 4 other judges, dissented. Judge Graves joined the dissent in part. The en banc Fifth Circuit's decision conflicted with those of other circuits, and we granted the FDA's petition for a writ of certiorari. We now vacate and remand. The question we agreed to decide is whether the FDA acted arbitrarily and capriciously in denying respondents' applications for pre-market approval of their tobacco products. But before tackling that question, we briefly address as a preliminary matter an argument that is touched on in respondents' brief, namely, that either the APA or the TCA required the FDA to use notice and comment rulemaking to set out the requirements that must be met in a pre-market tobacco product application. Unless Congress has specified otherwise, agencies are generally free to develop regulatory standards either by general legislative rule or by individual order in an adjudication. Of course, if a statute requires rulemaking, the affected agency must comply. And that is what respondents claim in passing here. Respondents' defense of the decision below is based almost entirely on relevant case law. But their brief also suggests that the FDA's decision to issue denials based on standards developed in adjudication violated other provisions that, they claim, required notice and comment rulemaking. This echoes an argument the Court of Appeals made in a short footnote. We did not grant certiorari on that question, and without adequate briefing, it would not be prudent to decide it here. Accordingly, we do not reach that question and express no view on its merits. We now turn to the Court of Appeals holding that the FDA acted arbitrarily and capriciously. That decision was multifaceted, but its analysis boils down to a central concern. It faulted the FDA for allegedly changing the requirements for pre-market tobacco product applications between the time of its guidance and the denials of respondents' applications. The feature of our current case law on arbitrary and capricious review that addresses that issue is our change in position doctrine. Under that doctrine, we must ask whether the FDA changed course and, if it did, whether it offered satisfactory reasons for the change. Analysis of the FDA's position prior to the denials at issue requires a close reading of nuanced statements in a body of guidance documents that evidence the agency's evolving assessment of the relevant issues. Affected parties may have come away with the impression that the agency would apply a less demanding standard of proof than is evident in the denial orders the FDA ultimately issued, but in the end, we cannot say that the FDA improperly changed its position with respect to scientific evidence, comparative efficacy, or device type. With respect to the FDA's guidance on marketing plans, we clarify the appropriate legal standard governing claims of harmless error, and we remand to the Fifth Circuit to apply that standard in the first instance. We begin with our change in position doctrine. The APA requires a reviewing court to hold unlawful and set aside agency action found to be arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with law. Our well-worn arbitrary and capricious standard ensures that an administrative agency examined the relevant data and articulated a satisfactory explanation for its action, including a rational connection between the facts found and the choice made. The scope of this review is narrow, and reviewing courts must exercise appropriate deference to agency decision-making and not substitute their own judgment for that of the agency. Our case law identifies numerous ways in which an agency may act arbitrarily and capriciously. The Fifth Circuit concluded that the FDA overstepped this standard in 4 such ways. In its view, the FDA, 1. Invented post hoc justifications for its failure to consider applicants' marketing plans. 2. Failed to give fair notice of the evidentiary and comparative requirements that would be imposed at the application stage. 3. Changed its position regarding scientific evidence and device type. And 4. Faulted respondent for relying in good faith on its previous guidance. All 4 of these principles orbit around the same basic concern. An agency should not mislead regulated entities. The essence of respondents' argument is that the FDA told them in guidance documents that it would do one thing and then turned around and did something different when it reviewed their applications. The change in position doctrine is administrative law's answer to that problem. Under that doctrine, agencies are free to change their existing policies as long as they provide a reasoned explanation for the change, display awareness that they are changing position, and consider serious reliance interests. For reasons we explain, the change in position doctrine provides the governing framework here. Respondents appear to recognize as much, although they suggest at times that the applicable requirements are not just part of arbitrary and capricious review but are rooted in part on the constitutional right to due process. In substance, however, there is little difference in the standard they ask us to apply. They do not rely on 4 distinct administrative law principles. Rather, their arguments before this court rest primarily on the FDA's supposed change in position regarding application requirements. To the extent respondents raise a freestanding fair notice argument, the exact contours of that contention are somewhat unclear. By asking us to affirm the decision below, respondents do not now suggest that under the TCA the FDA had an affirmative obligation to issue specific guidance as to how it would evaluate flavored products. Instead, respondents merely support the Fifth Circuit's conclusion that when an agency issues guidance, it cannot change the requirements set forth therein without consideration of applicants' reasonable reliance interests, proper notice to applicants, and a reasonable opportunity for applicants to conform to the changed requirements. It is unclear what, if any, daylight exists between that conception of fair notice and our change in position doctrine. The change in position doctrine asks 2 questions. The first is whether an agency changed existing policy. And we have suggested that this occurs when an agency acts inconsistently with an earlier position, performs a reversal of its former views as to the proper course, or disavows prior inconsistent agency action as no longer good law. For example, we have held that an agency changed its position when it rescinded a prior regulation, expanded the scope of its enforcement activity, and abandon a decades-old practice applied in enforcement actions. Once a change in agency position is identified, the doctrine poses a second question. Did the agency display awareness that it is changing position and offer good reasons for the new policy? At this second step, the agency does not need to show that the reasons for the new policy are better than the reasons for the old one, nor must it provide a more detailed justification than what would suffice for a new policy created on a blank slate. But the agency must be cognizant that long-standing policies may have engendered serious reliance interests that must be taken into account. Echoing the Fifth Circuit, respondents claim that the FDA violated the change in position doctrine with respect to the four principal themes discussed above. First, according to respondents, the FDA, after initially telling applicants that no specific kinds of scientific evidence were required, turned around and rejected all applications lacking evidence from a randomized controlled trial or longitudinal cohort study. Second, respondents claim, the FDA told applicants they had discretion to choose appropriate comparator products, but it ultimately denied applications on the ground that they failed to make specific comparisons between dessert, candy, and fruit-flavored products, on the one hand, and tobacco-flavored products on the other. Third, respondents claim that the FDA abandoned earlier guidance about the importance of device type and instead denied authorization to all dessert, candy, and fruit-flavored e-cigarette products regardless of device type. And fourth, according to respondents, the FDA went back on its word by failing even to consider their marketing plans. As to the first three issues, we conclude that the FDA's denial orders were sufficiently consistent with its pre-decisional guidance and thus did not run afoul of the change in position doctrine. As to the failure to consider marketing plans, the FDA does not seek review of the Fifth Circuit's finding of error. Rather, it asks us to clarify the harmless error rule and remand for application of the proper standard. We agree with the FDA that that is the appropriate course of action. We first address the FDA's position on scientific evidence. In respondents' view, the FDA initially stated that manufacturers would not need to provide specific kinds of studies like randomized controlled trials or longitudinal cohort studies, but then treated such evidence as essential. Respondents express frustration about the lack of clear prior notice regarding the type of scientific evidence that was essential for approval of an application. But we cannot agree with their argument that the FDA went back on any commitments made in the guidance it provided before ruling on respondents' applications. Both the Tobacco Control Act itself and the FDA's guidance left the agency broad discretion to decide what sort of scientific evidence an applicant was required to submit. The Tobacco Control Act itself imposes only basic requirements on this matter. It says that the agency's determination of what would be appropriate for the protection of the public health must be made based on either well-controlled investigations, which may include one or more clinical investigations by experts qualified by training and experience to evaluate the tobacco product, or other valid scientific evidence that is sufficient to evaluate the tobacco product. The Tobacco Control Act leaves it to the FDA to decide what constitutes a well-controlled investigation or other valid scientific evidence that is sufficient. Before ruling on respondents' and other manufacturers' applications, the FDA addressed the issue of scientific evidence in a series of lengthy documents and oral presentations by agency officials, but it is hard to find in all this verbiage any specific commitments about exactly what sorts of scientific evidence an applicant would have to provide. As we will detail below when we discuss the particulars of respondents' applications, the FDA commented on the strength of various types of evidence and how particular types of evidence would likely be evaluated, but at no point did it lay down any clear test. For example, during a public meeting, an agency official said that in most situations it is likely that at least some new analytical testing specific to the product would be conducted to support an application. The official then offered examples such as randomized controlled clinical trials, alternatives like pharmacokinetic, pharmacodynamic, biomarker, topography, or focus group studies, published peer-reviewed literature, and literature reviews more generally, but the official never stated that any particular type of study was necessary. On the contrary, the FDA acknowledged that it was open to evidence besides new non-clinical or clinical studies, and the FDA promised that it would consider evidence bridging new tobacco products to already marketed products whose safety was backed by existing clinical, non-clinical, or product information. None of this amounted to anything like a hard and fast commitment as to the minimum evidence the agency would require for marketing authorization. A guidance document was similarly non-committal. After reiterating the statutory requirement of well-controlled investigations, the document recognized that the relatively new entrance of e-cigarettes on the U.S. market meant that limited data may exist from scientific studies and analyses. As a result, the document stated, the FDA would consider other valid scientific evidence if found sufficient, but it cautioned that non-clinical studies alone are generally not sufficient. The guidance document went on to give examples of other evidence that might suffice, but in doing so, it cautioned about the need for scientific rigor. For example, while stating that applicants could cite data from the published literature or government-sponsored databases, it warned that such data must be adequately bridged to your product with a scientific rationale. The document told manufacturers that they could also cite published literature reviews, including meta-analysis, but that such evidence is considered a less robust form of support. And applicants were advised that they could conduct independent analyses of published studies, but that if critical study details are not submitted, the studies may not be useful in FDA's review. A fair summary of the main point made in all this guidance is that, a. It was not essential for manufacturers to submit evidence based on well-controlled investigations, such as randomized controlled trials or longitudinal cohort studies, but b. If they did not do so, they would have to provide rigorous scientific evidence that the sale of their particular products would be appropriate for the protection of the public health. In this case, the applicants did not submit randomized controlled trials or longitudinal cohort studies, so the fate of their applications turned on whether they submitted other evidence that met the FDA's standard of scientific rigor and relevance to their product. The FDA rejected respondents' applications because it concluded that its other evidence test was not met, and the explanation in its denial orders echoed statements made at various points in its earlier guidance. Both respondents relied on a comprehensive review of the scientific literature, but respondents had notice from the guidance that the FDA considered literature reviews a less robust form of support. The guidance also instructed that applicants submitting literature reviews should, among other things, include comparative assessments of the health risks associated with use of a manufacturer's new tobacco product, compared to the risks associated with quitting tobacco product use, using other tobacco products, and never using tobacco products. Respondents' literature review did the opposite. It concluded that there is not enough evidence to determine whether e-cigarette flavors aid in smoking cessation. One of the respondents, Vapitasia, submitted results from a cross-sectional survey finding that 82.99% of survey respondents indicated that e-cigarettes help them quit smoking combustible tobacco, but the FDA concluded the survey was not adequately tied to Vapitasia's flavored products. That requirement echoed the guidance's advice that manufacturers submitting evidence from new non-clinical studies should explain why a study is relevant to use for the manufacturer's product, for example, the similarities between the product use, or product market. Based on the FDA's largely non-committal guidance on scientific evidence and its specific reasons for rejecting respondents' applications, we cannot say that the agency deviated from a prior policy sub silentio or simply disregarded what it had previously said. In line with the agency's prior guidance, each denial order was based on the applicant's failure to provide either evidence from well-controlled investigations, such as a randomized controlled trial and/or longitudinal cohort study, or other evidence that was found to be reliable and robust. No change in position occurred in this respect. Contrary to respondents' contention, this conclusion is not undermined by the FDA's scientific review form, which contained checkboxes to indicate whether an applicant submitted a randomized controlled study, a longitudinal cohort study, or other evidence related to potential benefit to adults. Criterion C appears to defeat respondents' argument, but they contend that the FDA made it clear that this criterion demanded a study of the effect of flavored products on adult smokers over time, and that this requirement duplicated Criterion B, which looked for a longitudinal cohort study. This argument fails because a longitudinal cohort study and evidence of a product's effects over time are not the same thing. The term longitudinal study is typically used to describe a particular kind of long-term study, namely, one that employs continuous or repeated measures to follow particular individuals over prolonged periods of time, often years or decades. Not every study that considers a product's effects over time falls within this understanding. Based on the FDA's internal memoranda from the summer of 2021, respondents argue that the agency secretly enforced a new requirement that manufacturers must submit evidence from either a randomized control trial or longitudinal cohort study. Recall that the FDA's memorandum stated that the failure to submit such evidence would constitute a fatal flaw that would likely result in denial of an application. Even though this statement, like most of what the FDA said in its guidance, was not categorical, it certainly suggested a much harder stance than was implied by the FDA's public statements, which told applicants that other evidence might be capable of proving a new tobacco product's appropriateness for the protection of public health. Respondents suggest that the FDA surreptitiously applied the fatal flaw memorandum, and as evidence, they note that until well after their applications were denied, the FDA rejected all applications for flavored products. But agencies are entitled to a presumption of regularity, and the record offers enough support for us to conclude that the FDA never enforced a rigid fatal flaw standard. To start, a later internal memorandum dated August 17, 2021, appeared to contradict the fatal flaw memorandum. The new memorandum represented that the FDA would also consider evidence from another study design besides randomized controlled trials and longitudinal cohort studies, provided that it could reliably and robustly assess behavior change and compare users of dessert, candy, and fruit-flavored products with those of tobacco-flavored products. The FDA also acknowledged that indirect evidence or bridge data from the literature might still be appropriate for many new products too. Even though the FDA predicted these other types of evidence would not likely be sufficiently robust or direct, the August 17, 2021, memorandum is unambiguous that the FDA would nevertheless consider such evidence. This memo might be viewed as dooming any argument based on the earlier fatal flaw memorandum, but on August 25, 2021, the FDA rescinded the August 17, 2021, memorandum and represented that it would not consider or rely on it as a supporting document. Rescission of the August 17 memorandum raises the question whether that action effectively reinstated the July 9, 2021, fatal flaw memorandum or was a pretext to mask the FDA's adherence to secret criteria. But the FDA represents that these internal memoranda played no role in its review of applications, and for us to peel back the curtain on that representation would have required respondents to make a strong showing of bad faith or improper behavior. Respondents have not surmounted the high standard that must be met to warrant such a substantial intrusion into the executive's functioning. We thus conclude that respondents failed to show that the FDA changed its position with respect to the scientific evidence supporting pre-market tobacco product applications. Next, we turn to the FDA's comparative efficacy requirement, which called on manufacturers to compare the health effects of their dessert, candy, and fruit-flavored products to those of tobacco-flavored products. On respondents' reading of the record, the FDA initially gave applicants broad discretion to select appropriate comparators for their products, but it later categorically rejected applications that failed to show that flavored e-cigarettes promote more switching than unflavored or tobacco-flavored e-cigarettes. The record does not suggest that the FDA contradicted its pre-decisional guidance by requiring certain cross-flavor comparisons. To start, the TCA expressly contemplates comparisons of different tobacco products. It requires an applicant to provide full reports of all information concerning investigations which have been made to show whether its tobacco product presents less risk than other tobacco products. Moreover, the FDA's determination that a new tobacco product is appropriate for the protection of the public health is an inherently comparative judgment. The FDA must account for the increased or decreased likelihood that existing users of tobacco products will stop using such products and the increased or decreased likelihood that those who do not use tobacco products will start using such products. This balancing test calls out for various types of comparisons, including comparisons between new tobacco products and those that are already available, as well as between different types of new tobacco products that may attract new smokers. Through its pre-decisional guidance, the FDA elaborated on the types of comparisons that would be helpful. Echoing the TCA, the June 2019 guidance document recommended that a manufacturer compare the health risks of its product to both products within the same category and subcategory, as well as products in different categories as appropriate. The FDA went on to explain what it means for manufacturers to make comparisons to similar, marketed tobacco products in the same category. For example, it advised, if your application is for an e-liquid, we recommend a comparison to other e-liquids with similar nicotine content, flavors, and other ingredients, used in the same manner and under similar conditions. The plain implication of this statement is that the FDA might consider whether an application for a flavored product included a comparison with other products in the flavored category. Other parts of the 2019 guidance also underlined the FDA's concern about the potential impact of flavors on product toxicity and appeal to youth and young adults. The FDA noted that it considers the appeal and use of e-cigarette product flavors important in ascertaining the health risks of these products and thus recommended scientific reviews of flavors. Specifically, it called on manufacturers to examine the impact of flavoring on consumer perception, especially given the attractiveness of flavors to youth and young adults. Further, in its 2020 enforcement guidance, the FDA telegraphed its view that dessert, candy, and fruit-flavored e-cigarette products are more likely than tobacco and menthol-flavored products to appeal to the young. The FDA noted its intent to prioritize enforcement of flavored e-cigarette products, other than tobacco and menthol-flavored products, and observed that youth use of mint and fruit-flavored e-cigarette products is higher than that of menthol and tobacco-flavored e-cigarette products. The FDA also relied on data that flavors like tobacco and menthol were preferred more by adults than youth. When it reviewed respondents' applications, the FDA did not contradict any previously announced position with respect to the comparative effects of differently flavored products. As respondents' marketing denial orders stated, their applications were unsuccessful because they failed to demonstrate the benefit of their dessert, candy, and fruit-flavored e-cigarette products over an appropriate comparator tobacco-flavored e-cigarette product. Admittedly, the FDA has not pointed us to any portion of its pre-decisional guidance that said in so many words that manufacturers must draw that precise comparison. And, in fact, the 2019 guidance gave manufacturers some discretion in choosing appropriate comparators as long as the FDA could understand an applicant's rationale and justification for comparators chosen. But the FDA's comparative efficacy standard was a natural consequence of its pre-decisional guidance, which highlighted, among other things, 1. The need for robust cross-product comparisons, including on the dimension of flavor, and 2. The FDA's heightened concern with dessert, candy, and fruit-flavored products compared to tobacco and menthol-flavored products. Such a predictable outgrowth from previous guidance is not an unexplained inconsistency amounting to a change under the change in position doctrine. Respondents contend that the FDA said nothing about comparing dessert, candy, and fruit-flavored products to tobacco-flavored products, and even suggested manufacturers could freely select comparators as long as they provided adequate justification or rationale for their comparator choice. As we noted, respondents are correct that the FDA did not provide this precise instruction in its pre-decisional guidance. But as an FDA official noted at the 2018 public presentation, manufacturers were encouraged throughout the application process to think hard about what is or are the most appropriate comparators to their products. And the agency's subsequent guidance emphasized the importance of cross-product comparators and the FDA's specific worry that dessert, candy, and fruit-flavored products would appeal to youth more than tobacco and menthol-flavored products. The FDA is thus better understood as having extended, not reversed, its previous guidance. Quite tellingly, respondents appear to have received the FDA's message on this front. Their applications are replete with statements attempting, albeit unsuccessfully, to draw comparisons between dessert, candy, and fruit-flavored and tobacco-flavored products, the same sort of comparisons for which the FDA allegedly provided no notice. All that is to say, respondents' applications are themselves strong evidence that regulated entities had adequate notice of the sort of comparative analysis the FDA anticipated. Furthermore, even assuming the pre-decisional guidance did not perfectly predict the comparative efficacy standard ultimately applied to applications, the FDA was not required to issue such guidance in the first place. Respondents do not argue that the TCA imposed an affirmative obligation on the FDA to spell out in detail how it expected applicants to compare a new tobacco product to other tobacco products. Rather, as we have explained, the FDA had discretion to work out the meaning of the TCA's comparative standard when evaluating pre-market tobacco product applications. A contrary rule would be in tension with the teaching that, absent a statutory prohibition, agencies may generally develop regulatory standards through either adjudication or rulemaking. Finally, we turn to the issue of device type. In respondents' view, the FDA's 2020 guidance saw a material distinction between cartridge-based and other flavored products, but when it came to ruling on applications, the FDA effectively imposed a flat ban on all flavored products. We cannot agree with respondents that the denial order's treatment of device type was inconsistent with any earlier position. The 2020 guidance explained how the FDA intended to prioritize its enforcement resources. Specifically, the agency planned to target 3 types of e-cigarette products: 1. Flavored, cartridge-based products; 2. All other e-cigarette products for which the manufacturer has failed to take, or is failing to take, adequate measures to prevent minors' access; and 3. Any e-cigarette products targeted to, or whose marketing is likely to promote use by, minors. Admittedly, on any reading of this guidance document, the FDA's central concern was the first category because data suggested youth are more likely to use certain flavored, cartridge-based e-cigarette products. But nothing in the 2020 guidance suggested the FDA would decline to take enforcement action against other products that might be appealing to the young. In fact, the FDA's enumeration of the second and third enforcement priorities, which are not limited to flavored cartridge-based products, supports the contrary conclusion. So when the FDA ultimately denied authorization to respondents' flavored, though non-cartridge, products, it did not reverse course. Rather, it followed through on the 2020 guidance's warning that the agency would also prioritize enforcement against manufacturers whose products' marketing is likely to promote use by minors. Indeed, the FDA's marketing denial orders stated that respondents' applications were insufficient to demonstrate that their products would provide an added benefit that is adequate to outweigh the risks to youth. That is a consistent application of the 2020 guidance's enforcement framework, or, at the very least, an application that did not reverse the FDA's former views as to the proper course. This case is unlike other instances where agencies change their position by expanding the scope of its enforcement activity. Here, the FDA's 2020 guidance did not establish a safe harbor for non-cartridge-based products. True, the 2020 guidance unmistakably emphasized cartridge-based products, but it said nothing to suggest dessert, candy, and fruit-flavored products for open-system e-cigarettes would escape regulatory scrutiny. And further distinguishing those cases, the FDA's actions here did not break new ground. Indeed, there was no new ground to break because respondents' denial orders were part of the FDA's first major exercise of its new authority over tobacco products under the TCA. In other words, the FDA could not expand the scope of previously non-existent enforcement activity. Even if the FDA had changed its position, it offered good reasons for looking beyond cartridge-based e-cigarette products, namely, that there was evidence from national surveillance data that youth demand had moved from flavored cartridge-based products to flavored disposable products. From this, the FDA drew the conclusion that across these different device types, the role of flavor is consistent. If one type of flavored product were removed from the market, the FDA concluded, youth would migrate to another type of flavored product. So the FDA decided to focus on the role of flavors across tobacco product categories. The FDA made this conscious change, of course, because it believed it to be better, and the agency gave good reasons for the change. Respondents cannot claim that the FDA's revised enforcement priorities upset a legitimate reliance interest. At most, the 2020 guidance may have led respondents to believe that the FDA was more likely to authorize their open system products than other manufacturers' cartridge-based products. But such a belief about how an agency is likely to exercise its enforcement discretion is not a serious reliance interest. Our prior change in position cases have set a much higher bar, requiring, for example, decades of industry reliance on an agency's prior policy. Here, in contrast, respondents could not have built up decades of reliance because they were part of the very first wave of marketing denials under the FDA's newly minted jurisdiction over tobacco products. We thus hold that the FDA's treatment of device type, even if it evolved over time, did not violate the change in position doctrine. Respondents take issue with the FDA's explanation that it changed enforcement priorities based on evidence that youth demand shifted from cartridge-based products to disposable products. In respondents' view, that evidence had nothing to do with products such as theirs that are intended for open-system e-cigarette products. And respondents cite evidence from a study finding that between 2020 and 2021 high school student demand for devices compatible with flavored bottled e-liquids actually decreased. This counterargument is not persuasive. Even though the FDA did not cite evidence that was specifically about increasing youth demand for open-system e-cigarette products, the FDA drew a reasonable inference based on the data before it, namely, that the rapid shift in youth demand from flavored cartridge-based products to flavored disposable products strongly suggested that youth were most strongly drawn by flavor rather than device type. We see no reason why the FDA could not extrapolate from that data and conclude that young people would be drawn to flavored products for open-system e-cigarettes. Regardless, we are not positioned in this arbitrary and capricious challenge to consider respondents' evidence from a study that postdates the filing of their applications and is, in any event, outside the administrative record already in existence. Nor is respondents' evidence of sufficient heft to call into question whether the FDA's factual determinations about the powerful effect of flavor is supported by substantial evidence in the existing administrative record. That brings us to the FDA's guidance concerning marketing plans. Recall that the FDA does not contest the Fifth Circuit's finding that it changed position regarding the submission of marketing plans, but it argues that this error was harmless. This question presents a difficult problem. It requires us to reconcile the so-called remand rule developed in SEC v. Chenery Corporation, and Chenery 2, with the APA's instruction that reviewing courts must take due account of the rule of prejudicial error that ordinarily applies in civil cases. In Chenery I, the court announced the now bedrock principle that an agency action cannot stand unless the grounds upon which the agency acted in exercising its powers were those upon which its action can be sustained. There, we rejected the Securities and Exchange Commission's belated request to affirm its action on an alternative ground raised for the first time in litigation. We reasoned that when Congress vests an agency with authority to make a determination of policy or judgment and the agency fails to exercise that authority, a judicial judgment cannot be made to do service for an administrative judgment. Upholding agency action on an alternative ground not considered by the agency, the court reasoned, would intrude upon the domain which Congress exclusively entrusted to an administrative agency. We reaffirmed this principle in Chenery 2, and a necessary implication of that principle is that the better course when an agency error is identified is for the reviewing court, except in rare circumstances, to remand to the agency for additional investigation or explanation. That implication of Chenery is colloquially referred to as the remand rule. 3 years after Chenery I was handed down, Congress enacted the APA. At that time, Rule 61 of the Federal Rules of Civil Procedure instructed courts not to disturb a judgment or order unless refusal to do so would be inconsistent with substantial justice. The APA picked up on this principle and required courts reviewing agency action to take due account of the rule of prejudicial error. Taking due account of a rule is not literally the same as applying that rule lock, stock, and barrel. The most natural interpretation of the APA's language is thus that reviewing courts should adapt the rule of prejudicial error applicable in ordinary civil litigation, also known as the harmless error rule, to the administrative law context, which, of course, includes the remand rule. The FDA's failure to consider marketing plans and its chosen arguments in litigation have set the remand rule and the APA's harmless error principle in tension. Despite assuring manufacturers in pre-decisional guidance that their marketing plans would be critical, the FDA refused to consider respondents' marketing plans when it reviewed their pre-market tobacco product applications. Based on its experience, the FDA opined that marketing and access restrictions on flavored e-cigarette products are, as a practical matter, categorically insufficient to sustain an otherwise inadequate application. The Fifth Circuit held that this about-face was arbitrary and capricious, and the FDA has not sought review of the Fifth Circuit's threshold finding of error. Instead, it expands upon an argument it raised before the Fifth Circuit, and contends that its failure to consider marketing plans was harmless error because, subsequent to denying respondents' applications, it issued denial orders to other manufacturers after reviewing marketing plans that were materially indistinguishable from respondents. That is proof, the FDA says, that reviewing respondents' marketing plans would not have made a difference. The Fifth Circuit rejected the FDA's harmless error argument based on our most recent decision invoking the remand rule. In that case, after reciting the remand rule in strong terms, we acknowledge that a remand may be unwarranted, where the agency was required to take a particular action. The Fifth Circuit interpreted this discussion to mean that there is only one exception to the remand rule. That is certainly a plausible interpretation, but it would imply a need to remand for all but the narrowest category of agency errors, minimizing the role of harmless error review. The FDA disagrees with this broad reading and cites, among other authorities, our decision in Sanders. In that case, we opine that the APA incorporates the same kind of harmless error rule that courts ordinarily apply in civil cases. That principle, taken to its logical extreme, could permit a reviewing court to sustain a flawed agency decision whenever it finds that the agency would have reached the same result absent the initial error. Understood in that way, harmless error might swallow the remand rule. There is thus obviously tension between the cases, and neither decision sought to harmonize the remand and harmless error rules. The court made no reference to the APA's prejudicial error provision, and Sanders did not discuss the remand rule or even cite Chenery. For now, we agree with the FDA that the Fifth Circuit read the prior case too broadly. It has long been accepted, for example, that a remand may not be necessary when an agency's decision is supported by a plethora of factual findings, only one of which is unsound. When it is clear that the agency's error had no bearing on the procedure used or the substance of the decision reached, a remand would be pointless. We do not suggest that this exception and the one recognized exhaust the universe of exceptions to the remand rule. But the existence of this exception is sufficient to show that the Fifth Circuit's reading went too far. That said, the FDA's reading may also be excessive. In an article that the FDA quotes with approval, Judge Friendly accurately captured the core of the remand rule when he wrote, "Where the agency has rested decision on an unsustainable reason, the court should generally reverse and remand even though it discerns a possibility, even a strong one, that by another course of reasoning the agency might come to the same result." There is an important distinction, if only a subtle one, between this formulation and the FDA's argument that a party attacking an agency decision must prove that an error had a substantial bearing on the decision. And the FDA has not identified any prior case in which we have held that the application of an erroneous understanding of the governing law was harmless because a subsequent agency decision shows that the agency would have reached the same result if it had applied the correct understanding of the law. The FDA has not asked us to decide the harmless error question at this juncture. True, in its petition for certiorari, it requested that we review and reverse the Fifth Circuit's holding that the error was not harmless, but the FDA unmistakably abandoned that full-throated request after we granted certiorari. In its opening brief, the FDA asked that we only identify the correct harmless error rule and remand the case, allowing the Fifth Circuit to determine whether respondents have met their burden of showing prejudice. It reiterated that position in its reply. And at argument, when asked, the FDA was upfront that it seeks vacatur and remand so the Fifth Circuit can decide the question afresh without relying on its overly expansive reading of the prior case. We follow that course. For these reasons, we vacate the judgment of the United States Court of Appeals for the Fifth Circuit and remand the case for further proceedings consistent with this opinion. It is so ordered. Justice Sotomayor, concurring. I join the court's opinion, as it rightly rejects the contention that the FDA acted arbitrarily and capriciously in denying respondents' applications for pre-market approval of their tobacco products. I write separately, however, to clarify one point. I do not believe the FDA, in the lead-up to denying respondents' applications, was feeling its way toward a final stance and was unable or unwilling to say in clear and specific terms precisely what applicants would have to provide. Instead, the record shows the agency reasonably gave manufacturers some flexibility as to the forms of evidence that would suffice for pre-market approval of their products, while hewing to, and never suggesting it would stray from, its statutory duty to approve only those products that would be appropriate for the protection of the public health. In light of the statutory text and the well-documented and serious risks flavored e-cigarette products pose to youth, it should have come as no surprise that applicants would need to submit rigorous scientific evidence showing that the benefits of their products would outweigh those risks. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.